May it please the court, I appear today pro se because my parents said I couldn't afford counsel, and also apparently bedtime is non-negotiable. But I stand, or rather wobble, before you to assert my fundamental, inalienable, and constitutionally guaranteed right to free speech under the First Amendment to the United States Constitution, ratified 1791, long before my parents invented the no yelling at dinner rule.
Counsel, you're saying your parents' household rules constitute a First Amendment violation.
Exactly, Your Honor. Their so-called quiet hours policy is nothing short of prior restraint, condemned in Near v. Minnesota, 283 U.S. 697, 1931. They are, in effect, censoring speech before it happens. When I attempted to engage in protected expressive conduct, namely the 3 a.m. protest chant of Mama, Dada, Wah, I was silenced without due process. A clear violation of the 14th Amendment's due process clause.
But isn't parental discipline a compelling state interest?
Not when narrowly tailored alternatives exist, Your Honor. Perhaps a time, place, and manner restriction under Ward v. Rock against Racism, 491 U.S. 781, 1989. Say, a designated cry zone near the crib, but not an outright ban on expression. Furthermore, my parents' enforcement mechanism, specifically the timeout, constitutes cruel and unusual punishment, violating the 8th Amendment as applied via incorporation.
Counsel, what relief are you seeking?
Declaratory judgment that the no talking during nap time statute of the household is unconstitutional, and injunctive relief enjoining further enforcement. Also, nominal damages in the form of 1 additional bedtime story and unlimited access to goldfish crackers.
And what do you say to the respondent's claim that your speech is disruptive to domestic tranquility?
With respect, Your Honor, domestic tranquility was never intended to come at the expense of liberty. As Justice Brandeis once said, fear of serious injury cannot alone justify suppression of free speech. Whitney v. California, 274 U.S. 357, 1927. Besides, my so-called disruptive speech is, in truth, the marketplace of ideas, and in that marketplace, I am the loudest bidder.
Any closing remarks?
Yes, Your Honor. If the court upholds my parents' unconstitutional gag order, we risk setting a dangerous precedent. Today it's no yelling. Tomorrow it's no cartoons before breakfast. The Constitution was written to restrain tyranny, not toddlers. I rest my case.